5 minutes for rebuttal, please.
5 minutes, yes, sir.
Under this instrument right here is for Mr. Pernick. It's the device that he needs for to hear. So he explained to me that it's going to be used for.
Do you want to save any time for rebuttal?
I said 5 minutes.
Forgive me, I didn't hear you. Thank you.
Yes, Your Honor. Your Honor, this is a case. I represent the father and the stepmother who's attempting to adopt. The stepmother's attempted to adopt the child. These parties were the appellants, my clients, were married in January of 2019. Mr. McCoy is the father of Brooklyn, who was born in 2015. Currently, she's 8 years old, and she just started the third grade yesterday in her school. But anyway, there's a couple things that my brief is long and extensive, and I tried to shorten it as much as I could, but there was a lot of issues that I felt I needed to address. But for today's purposes, what I would like to just summarize some of those things very quickly. One of the first issues that I wanted to address was my clients had asked the court to find that the mother had failed to manifest by act or omission an ability or willingness to personally assume legal and physical custody or financial responsibility of the child, and placing the child in the person's legal and physical custody would pose a risk of substantial harm to the physical or psychological welfare of the child pursuant to TCA 36-1, 113G14. The issue was raised by Mr. Pernick that in his brief that this wasn't initially pled before the court, and I wanted to point out that it is in the petitioner's brief. In the petitioner's petition, on paragraph 30 of the brief of the petition, that ground is pled. It said it would be in the child's best interest under TCA 36-1, 113 to terminate respondent's parental rights under TCA 36-113G, and it goes on to say G14. So it was originally pled. Also, as part of that, it was asked for throughout it, but again, we believe that the court was wrong by not finding that ground. It's our position that that due to the fact that Miss Wheaton had by her past behavior, she had failed to show the willingness and the ability, and the fact that the things that she was doing now to correct her past problems were done while she's in drug court. Everything she did was required by drug court to participate and to keep from going to jail. I submit to the court that shows that her ability to parent is not there, because without the intervention of the court.
How do we reconcile that with the point that he denied her access, in fact, denied any communication with the child?
I'd reconcile that by, and if you'll look in the record, and she disappeared. She left the child's life in January. She said January 1st. He said December 26th of 18. She said January 1st, 2019. If you'll look in the record, the only time, she admitted this, the only times that she called, that Miss Wheaton called the father during this time was during the days where she happened to be sober. She said that on any given day between January 1st of 2019, September 11th of 2021, on any given day, she couldn't say, but on any given day, there was very good possibility that she was high that day. She went on to say that when she would reach out, on the days that she was sober, is when she would call. So the only time she tried to accomplish visitation was on the 1 or 2 days that she happened to be sober. Also, she contacted Miss McCoy by Facebook in February of 2019. Miss McCoy told her, you need to be consistent in your lifestyle. Ms. Wheaton went on to say, well, her attorney asked her that question, what does be consistent mean? She said, what I'm doing now. And she understood that to mean stop using drugs, get a job, quit running around. So during this time that she was denied visits, it was during the time that she was using, and she admitted she only tried to get visits when she was the 1 or 2 days where she was sober. That's how I believe that addresses that issue.
What about her family? Her family, it's my understanding from the record that her family also attempted to try to contact the father regarding seeing the child.
And they probably did. I'm not saying that they didn't. I know it's in the record. They didn't present any proof in the record that they said that they reached out. They didn't say how many times. They just said they reached out. But I would point out that is the family reaching out, not Miss Wheaton. And during this time, Miss Wheaton admits during that whole period that she said she'd been arrested a couple times. She was using that entire time. So I would say this case is not about her grandmother or her sister. This is about Miss Wheaton, and Miss Wheaton is the one that tried to do nothing for herself. Did I address that, Your Honor?
No.
Okay. Anyway, also, on far as the issue of abandonment, the relevant time period here is July 29th, 2021 through November 29th, 2021. First of all, that issue wasn't raised at the trial court, so I would say that if Mr. Pernick wants to claim that that's the relevant time that she might have been in jail during some of that time, that wasn't raised at trial. However, we do know she was in jail in June of 2021. She got out, she went to rehab, then she went to the halfway house. She submitted an exhibit dated July 30th of 2021 where she completed a number of classes in rehab. So unless that certificate is not worth the paper that it's written on, she completed that whole program in 1 day. So I would submit that on July 30th, she was in rehab on July 30th, where she completed the program. But I would submit also to the court that, just like the court found, that she that she had failed to willfully failed to visit, willfully failed to support the child during this time. At one point in time in 2021, September 2021, she was working, making $1,200 a week. She didn't pay any support during that time. And to get on to the final thing, the best interest, the court ruled against my clients, finding that it wasn't in the child's best interest to terminate. And I in my brief, I went through a lengthy discussion of that. I would point out that I think the most accurate representation here of where the court is wrong is Brooklyn does not know Miss Wheaton. And it was all brought about because of Miss Wheaton's choices. Miss Wheaton is the one that disappeared for, at that time, 2.5 years. She's the one that went on, she calls it relapse. It was a drug binge lifestyle choice that lasted 2.5 years. These were all her choices. Everything that she did to correct.
Made the choice, but it's also, what about the fact that these choices, that is when she first found out that the husband was having a relationship and that the husband would basically abandoned her at the time.
Well, Judge, with all due respect, we all have issues that pop up in our lives that we have parents that die and people have car wrecks. We don't go on 2.5 drug binges and abandon our kids. So I don't believe that that's an excuse.
That would excuse that, but it almost appears that he set things in motion for her, and she, of course, took the bait and went off on this binge.
Well, I would agree if it was just, if we were talking about she went to a party and took a hit off of a joint, I would say yes, that might be, but we're talking about what became a relapse turned into a lifestyle, and I think that's where we're going with this. It became her lifestyle. She was getting arrested, she was homeless, she was using drugs, and I don't believe that can be blamed back at the feet of my client when it was a choice that she made. But Again, I think the most strong point is, and I trust that the court has read the brief, and that Miss Wheaton made a choice to abandon her child, and that child no longer has a relationship with her at this point. Child's 8 years old, doesn't even know her mother. And my time's up.
Thank you, Mr. Mills. We'll now hear from the appellee. Good morning.
May it please the court, Nick Perenick for the appellee, Holly W. in this case. So this is a case where the mother's made some bad choices. The mother's first bad choice was she met Mr. McCoy. She got pregnant by him. Then, as you see in the brief, shortly after she got pregnant or so in 2015, he got in a car accident and got addicted to painkillers. And he was addicted to painkillers for at least 4 years, going up until around 2019 when they split up. She chose to stay with him and raise not only her child, Brooklyn, for 3.5 years, also her younger sister, as well as one of Mr. McCoy's children for 3 years. Then in December of 2019, around Christmas time, he announces, "I'm leaving." 2 weeks later, he marries another woman. She admittedly makes a bad choice and has a relapse, tries to get back and talk to him and call him. He ignores her family, hides this child for the next 2 years and change until they file a termination of parental rights. One of the issues
Is it in the
here...
record as to any steps, the additional steps that she took to try to get visitation or get to see this child? Did she attempt to petition juvenile court or take any other steps to make connection with this child?
Her going to take steps to court?
Yeah, to make
Okay.
communication with this child.
And that's the question. She did say she went to court one time during the pandemic and they were closed or she couldn't file anything. And a lot of this was during that pandemic when courts were on a limited schedule. However, there's the issue is, as far as visitation or support, whether or not she was blocked by the parents. A lot of folks in the appellant may say in this case, because she didn't go to court and get an order or file a petition, that means that she was not blocked. However, the court recently in the case of the Supreme Court in the case of Mattie L said, no, you can look at what the prospective adoptive parents are doing. If they're blocking phone calls, not making contact, not doing anything, that's evidence that they are blocking the visitation, and that failure to visit is not willful. And you can see here part of it's credibility. And the parents, the step-parents said, well, they reached out. Well, the dad testified at first she contacted him one time. Then later on he testified, well, yeah, we had communication for a couple weeks about this. Then he testified the family had never contacted him. And we heard in the record, and the judge believed, the 3 members of the family who came in and said, we were all trying to make contact with Dad and see this child because we care about her. It's clear that Dad and stepmom were blocking the mother's contact with the child through there. The issue of abandonment, we would take abandonment by failure to visit. The dad and stepmother were blocking that. The issue of failure to provide support is an issue that the mother clearly did not provide support for that 4-month period. However, the record's unclear as to whether she was incarcerated during part of that 4-month period prior to the finding of the petition. And she admitted she was incarcerated in June for a while. Later on in September, she was in a halfway house. It's petitioner's burden to prove that the mother failed to support for either the 4 months prior to filing a petition or if she was in jail for 4 months prior to that or part of that 4-month period. They failed to do this. Additionally, a court case says if the mother admittedly in September through November was in a halfway house as well as in rehab working her program, that is a reason not not to find that failure to support is willful, because there's an issue of whether she can work at that time and provide support. So on the issue of abandonment for failure to support or failure to visit, we believe that both of those must fail. On the issue of failure to manifest a willingness and ability, yes, in the body of the petition, in the allegations, there's an allegation as to that failure to manifest an ability or willingness. At least part of one, they missed part of the statute. But the important part is, if you read In Re MJB, a case from 2003 or so, the court specifically stated that in order to make an allegation and use one of those grounds for termination of parental rights, it must be pled in the prayer for relief. And in the prayer for relief in this case, the only ground that was claimed was abandonment. So it's important to read that case, and it's clear black letter law that says you must put it, if you're terminating parental rights, in that prayer for relief, because otherwise the respondent is not on notice that that's what you're claiming. Even though you may put all sorts of stuff in your allegations halfway there or full way there on the statute, unless in your prayer for relief you put that's what you're praying for relief for, that you want this court to find failure to manifest, then
You're
it's not
saying
valid.
that the prayer for relief has to restate all of the grounds alleged, or they're waived?
Absolutely. In Re MJB makes that clear. That was a case in which severe abuse was alleged in that the mother, the children were victims of severe abuse. There was another issue there, but it was in the allegations, but in the prayer for relief, termination of parental rights was not requested on the grounds of severe abuse. However, the court found that. The Court of Appeals, Judge Koch at the time, stated that it's not in that prayer, it is not pled. In addition, if you read the thing, it was not even mentioned in the opening statement, closing argument. It was not tried. We could try something by agreement, but it was not part of the trial at all.
Did
Further,
the trial judge use the fact that mother attempted, in fact, not only attempted, but actually waived termination at one point? Did he use that against her?
I'm sorry, Your Honor, I missed
The fact
that.
that the mother waived termination, that she agreed to terminate, to the termination at one point. Did the trial judge use that against her?
That you waived the
She waived her
termination?
parental rights, and then she rescinded that waiver, didn't she?
Yeah, so she
Was
did
that-
at one point surrender, but then revoke the surrender. But that, I believe, is not of any consequence at this point. A parent has a right to revoke a surrender within 3 days now, and if they do so, it can't be held against them at a later date or in the termination of parental rights. She may have thought one way and then thought another, because at the time of trial, she was doing rather well. She had her own house, she had her job, she had maintained contact with her family, she had everything that was needed to take care of this child, and the judge found that at that point that she was able to take care of the child fully. And when you get to best interest, you can notice the judge went through all 20 factors of best interest that are now in the statute, and found that 14 of them weighed in favor of the mother of not terminating parental rights. He thought it would be better for these parents, this child, to have a stepmother that maybe she lived with and a mother that she visited. You can see that in the trial, there were some concerns about the father and the stepmother. The father suffered from schizophrenia, which was being treated. He also had past drug addiction issues. The stepmother ran a spa that was doing body-on-body massages for clients. And she admitted quite often during the trial that, well, we're careful because we have undercover police coming in all the time. Now, her reasoning was the undercover police officer coming in to check to make sure that they were giving body rubs instead of massages, because massages you had to be licensed for. But there would have been some concern of the court that maybe this family unit here with the father and the stepmother was not all that stable either. There were issues there, and the judge looked at that as far as best interest.
Getting back to best interest, Mr. Mills insists that the child doesn't even know the mother. Mm-hmm. Is that correct? And if so, how can it then be in the child's best interest?
So I think there are two things this court needs to look at, and I think the trial judge did look at it. Number one is there's a specific part in there, it wasn't the mother, but the child somewhere between 2 and 3 years after the father had cut off all contact. The child was with the father's parents in a restaurant, I believe it was Ashland City. And the child's aunt, who had lived with them for a year, lived with the mother and the father, the mother's sister, came into that restaurant. Child immediately lit up, called her by her nickname, and wanted to hug her. Well, she knew her extended family even after that absence. It would be an assumption that she would also know her mother, who was there every day for 3.5 years. The second part of it is the testimony of whether or not this child knew the mother. The only testimony there was the father and the stepmother. And as I stated before, there are credibility issues about mother calling. Dad even wouldn't testify about his schizophrenia. He started off with seizures, then went to seizures and mental issues, and finally schizophrenia. Dad also talked about his income was either $700 or $1,900 a month. We don't know which. He stated that the grandparents and nobody else had ever tried to contact him about this child. So the judge was expected to take all these different stories from dad and stepmom about her business and all of that, and then believe them because they were the only witnesses says the child doesn't know her mother or stepmother. It's obvious the child had some contact with dad's parents because of that visit because of that meeting at the restaurant. Why couldn't dad and stepmom have brought somebody else in to say, well, we've talked to this child, she has no recollection of mom? The fact of the matter is, I think if the child could recognize an aunt after 2 years of not seeing her, the child would recognize the mom. The mom was that primary caretaker for 3.5 years while dad was struggling with his drug addiction. Mom was there taking care of these children as well as his child. So the idea that mom is a complete stranger only comes out of two voices. Petitioners, dad and stepmother. It's clearly self-serving, and there was no backup for that. The issue of best interest, I think the appellant states that the judge went off script as far as consideration of some of those factors of best interest. He looked at them, and then the judge made a decision, talked about that factor, but talked about something that wasn't quite related or completely related to the absolute words of that factor. Well, one of the important things is in doing best interest, the statute says in determining whether termination of parental or guardianship's rights is in the best interest of the child, the court shall consider all of the relevant and child-centered factors applicable to the particular case before the court. And then it says those factors may include the following, and that's that list of 20. So whether the judge interprets one of these factors one way or another and maybe puts in a reasoning that doesn't quite fit the factor, it's fine. He's got to consider what is relevant in this case. And in this case, it's clear when you read the transcript, the relevance is that mom was able to take care of the child, that she had that relationship with him, that dad was basically guilty of hiding this child from mom and her family for all those years, that the child had a relationship with the extended family members also, as exhibited by the aunt, and that it would be safe and in the child's best interest to have two mothers, a stepmother and a mother, who could both take care of her. There is no question, this is a step-parent adoption, there is no question that the father and the stepmother had this superior, I guess, parental preference there, that they would continue to have custody of the child, at least at that point, unless something happened in the future. Mother would have visitation. So the circumstances for the child weren't going to change that much. And the judge saw this, that in the case of step-parent adoption, the step-parents would own, oh, I'm sorry. I'll stop now.
You can finish. Okay, all right. Well, thank you, Mr. Pernick. Mr. Mills?
Just briefly, Your Honor, I would point out under 36-1, 102-1, Section I, as it pertains to abandonment, the issue of willfulness is an affirmative defense, and it must be pled or waived, must be pled in the answer or by motion, otherwise it's waived. So the burden did not flip to, the burden is on Ms. Wheaton regarding the issue of willfulness, and I don't believe that she rebutted that anyway. Point at Mr. McCoy and Ms. Wheaton's drug issues are not the same. Mr. McCoy had an accident. He was under a doctor's care. He was highly supervised. He was functioning. Miss Wheaton's drug use was illegal. She went and she disappeared on the child for 2.5 years. So that, as well as Miss McCoy's business, that's just a smokescreen to take the attention off of Miss Wheaton for her abandonment or desertion of this child for at least 2.5 years. But I'd get back to what I've said repeatedly. You've got a child that does not know her mother. When we're speaking of answers or testimony that's self-serving, the testimony about Miss Wheaton's sister who saw the child in Springfield at a restaurant, that was self-serving on this lady's part. She's the only one who testified to that. And when we're in these trials, most of this testimony by both sides is self-serving. And that's just the way these things work. And just because it's self-serving doesn't necessarily mean it's not true. And again, I get back, this is a case where, due to Miss Wheaton's choices, she made over a 2.5-year choice to abandon this child, go off on a drug binge. She only came back to reality when she was faced with being locked up, or she was going to go to jail, or she had to go to rehab. She chose to go to rehab. She started making these steps at that point in time. We can't predict the future. I think the judge, in his best interest analysis, was saying, well, if this happens, if that happens, and that's true, but that applies in every case. If we think good about everybody, and in the future we think they're going to do right, nobody would have the rights terminated. Can't predict what she's going to do in the future, but I think we can look at what she's done in the past, and her past behavior is, unless the court's forcing her to do something, she doesn't do it. And I would submit that this court should reverse the trial court as it pertains to best interest. And thank you for your attention. Thank you.
All right. Thank you, Mr. Mills and Mr. Pernick, for your arguments. We'll take this matter under advisement. That concludes the morning docket.